So now we have Adi Goldiner from Tel Aviv University, who will be talking about the addiction outlier and disability anti-discrimination. Thank you.
Thank you very much. Okay. Thanks very much, everyone, for coming, and I'm really happy to be here and to share this work in progress with you. My name is Adi Goldiner, and I'm a postdoctoral fellow. I'm now at Tel Aviv University, and I used to be in Haifa University, and that's why this is what's written on my in the book, in the abstract book. Generally, my work is in law, and I do a combination of legal and political theory, philosophy of disability, and disability law broadly construed. I work on anti-discrimination law, employment law, and other things related to disability rights. And today I'm going to talk about the addiction. Okay, thank you. Something that I found interesting, and okay, one more thing to add, that I did my PhD here at King, and my research generally focused on the question of the definition of disability. And one of the things that I always found very interesting, like and puzzling, was the addiction outlier in disability and anti-discrimination law. And that is what I want to talk about today. So I will start by describing the addiction outlier and disability anti-discrimination law. And I will focus on the law in America, the Americans with Disabilities Act, which is the primary piece of legislation about disability discrimination in the US. The reason for focusing on the US is primarily because there are many cases there, many legal cases that I can draw from. And then I will try to explain the exclusion of addictions from disability, the category of disability in anti-discrimination law, by appealing to different conceptions of disability that I think underlie the act, the law. I will argue that they don't manage to give an adequate explanation of this exclusion. And then I will go on to propose another explanation that I call the external explanation, because it's not something that appears in the legislation. And I will argue that it has to do with a conception of disability that is somehow tragic, that is not a choice, that calls for pity and help, and that the addiction doesn't really fit with this kind of conception of what disability is. And then I will discuss, and I will say a few words about why we should favor a certain perception or a certain conception of disability and not the other one. So that's more or less how we'll proceed. Okay. So the ADA, the Americans with Disabilities Act, defines disability in the following way. Disability means one of three things. It can mean physical or mental impairment that substantially limits one or more major life activities, or a record of such an impairment, or a person that is being regarded as having such an impairment. So these are the actual disability, record of a disability, or perceived disability, three prongs definition of disability under the Act. Now, why is this important? Because to be eligible for the protection of the law, one needs to first qualify as having a disability in one of these ways. When we think about addictions, there are different kinds of addictions that people have, and they try to claim rights under the Act based on those conditions. So let's begin with sex and love addiction. According to the law, sexual behavior disorders are excluded from the category of disability. It's explicitly stated in the law. And then we see cases of people coming to court and saying that they have a sex and love addiction, and that they want to be protected from discrimination. And one of these cases was pretty recent. It involved Karen Manson. She worked as the director of IT operations. And I'm just saying, I want to tell you about some cases. They're not necessarily the leading legal cases, but I think that they demonstrate an interesting set of circumstances that can be illuminating. So she worked as an IT director, and during December of 2019, she told her supervisor that she suspects she may have a sex and love addiction. And then a few weeks later, one of the clients of the company had a problem with the website. The website was down. A few days later, she took a day off. She went there to seek treatment. And during that day, she was also diagnosed as having this addiction. The next day, she came back to the office. She informed her supervisor of her addiction. And that same day, she was dismissed. She went to court to say that she was discriminated on the basis of her disability. The employer argued that her dismissal had to do with the problem that they had with one of the clients that they served. But she said that she was the only one who was dismissed following that mistake. But more importantly, the case turned on whether or not she had a disability. And the court simply rejected her claim of disability. He said, the judge said that sexual behavior disorders are excluded under the Act, and that sex love addiction is a sexual behavior disorder. And her claim that one needs to distinguish between a sexual behavior disorder and a sex addiction, that merely means that that's what she claimed, that she views people in a sexual behavior, not necessarily behaving, she views people in a sexual way, but not necessarily behaving in a sexual deviant way. So therefore she should be protected. The court rejected this claim. So sex and love addiction is not even an impairment. By contrast, alcoholism and drug addiction are recognized as impairments. So the questions for these kinds of conditions is whether as an impairment, they significantly limit people in their major life activities. In alcoholism, one of the leading cases was the case in Bolshevik Coca-Cola, where the court said, okay, so the story was a guy that worked there for a few years. He was a very heavy drinker. In the morning, he functioned well in work, but during the mornings, he usually was hungover. So he used to close the door and answer emails, or I don't know what they did in the 90s when you close the door, but he did something that didn't involve, he did some kind of admin work that didn't involve interacting with people, because he said he was not a morning person, but actually he was just very agitated because of the hangover. And anyway, he had some behavioral issues at work, and he was eventually discharged. And when he claimed that he was discriminated because of his alcoholism, that I'm not going to go into all the details now, but generally he was an alcoholic, he was treated and he was dismissed because of his misconduct. It was related to his drinking. The court said that alcoholism, in his case, or maybe in other cases as well, was not significantly limiting his major life activity because its effects on ability is only transitional. It's not permanent. It's only when he drinks. So, and that's how the case was dismissed. And one thing to note about this is that this approach of limiting ADA protection was very common during the 90s. And then following a lot of criticism, Congress amended the act in 2008 and made the threshold for meeting the standard of what is substantially limiting much more lenient. So it's possible that cases can now, I mean, ever since, that people with alcoholism can maybe qualify because of this change. So it's maybe even if the effect is not permanent, they can qualify. Okay, now a drug addiction, which is what I want to focus on today. Drug addiction is an impairment under the Act, but an interesting question is, when does drug use turn into an addiction for the purpose of the law? And one of the interesting cases that I found was the Rhodes v. Board of Education. The story was the plaintiff was a former school bus driver. She worked there for 20 years, and then she failed a random drug test for usage of marijuana. She immediately, her employer wanted to dismiss her, but she wanted to resign for some unrelated, to avoid being discharged. She tried to withdraw her resignation. The employer refused. Then she tried to reapply for her job after seeking counsel, and her employer refused again. And then she filed a claim for disability discrimination. Now, the interesting thing here is that the court rejected her claim, but the interesting thing here is that it rejected her claim, saying that, how do we even know that she has an addiction? She presented no evidence except for her own testimony that she's been using marijuana since she was 16 for over 20 years. Sometimes she's been smoking all day long. But the court said, no, it's not enough. We don't know if she's addicted or not. Another interesting feature is that sometimes courts are willing to accept that the person has a drug addiction following treatment. So if they're entering rehab, then it means that they are addicted. Okay. Now, so this is more or less the addiction outlier in disability in the ADA. For purposes of this subchapter, a qualified individual with a disability shall not include any employee or applicant who is currently engaging in the illegal use of drugs when the covered entity acts on the basis of such use. Okay, so we have an employee using drugs currently, and then is being dismissed, disciplined, or whatever, and he's not protected. But a few interesting moves here in the jurisprudence make this protection even more, makes this exclusion even more broad. Okay, first of all, what is the relevant time frame? When do we, because we're talking about currently, okay? So the question is, what is currently and what is the relevant time frame? So one option is to say that if the person was dismissed on day, whatever, 5, and he was currently using drugs on day 5, then it means that it's okay. So it's exempted from the law. But another option is to say that even if the person was not dismissed on the day, but he was notified. So let's assume that this school bus driver was using drugs. Her employer knew about that, and instead of dismissing her on the day, he notified her that she will be dismissed. 2 months later, she is dismissed. In those 2 months, she's already seeking treatment, counseling and whatever, she's recovered, and then she's being dismissed. Two options. One is that the relevant time frame is when she was dismissed. She got the formal dismissal letter, let's say. The other option is that when she was notified, and note that if it's the other way, only when she was notified, then it means that employers have a much wider time frame to dismiss employees without this being considered disability discrimination. But I think that even the even more problematic interpretation had to do with the meaning of currently. Generally, what happens is that courts interpret the idea of currently not as currently on the day 5 that she was smoking, also if she was dismissed or notified, but in the weeks and even months prior. So if a person uses illegal drugs 6 weeks, 7 weeks, 8 weeks prior to being notified that they are going to be dismissed, this still counts under the law as being dismissing the employee for currently using drugs. And I just want to highlight one thing here is that what motivates this expansion is a desire to address employers' reasonable belief that the drug abuse remained an ongoing problem. And this is something that I will come back to later when I talk about why we should reject this exclusion. Okay. But the law is not only about currently using drugs, it also has this safe harbor provision, which means that if someone who used to use drugs, but is now in a rehabilitation program, so there we have two options. One is that he completed a supervised drug rehabilitation program, or that he is now participating in a supervised rehabilitation program and is no longer engaging in use of drugs, then this person should be protected under the Act. But courts have again interpreted this provision in a very, very narrow way. They say it's not enough that you sign into rehab. You have to be there for a substantial amount of time, and you have to show that you've been not using drugs for a substantial amount of time. And here I want to tell you about a case about a plaintiff, a woman who worked as a checker in a store. She was arrested for drunk driving and for possession of methamphetamines. And she could not post bail, so she remained in arrest for a few days. And then she was sent to a rehab center by the court. Overall, this lasted for 7 days, during which she missed 3 shifts in her work. And she was discharged from her job for abandonment. Now, in court, she said that at least her 3rd absence was not because of her drug use, but because she was already in rehab. And so therefore, she said, I should be under the safe harbor provision. But the court said no, because the safe harbor provision applies only to employees who have refrained from using drugs for a significant period of time. Lots of these cases are triggered by drug testing in the workplace. And this, I think that the issue of drug testing is really interesting, and it raises a lot of interesting questions. I don't want to go into all of them right now, but I just want to say something about the one strike rule. which again goes to some of the justifications and reasoning for not applying the ADA protection to drug addicts. So generally, drug testings are allowed under the Act. They don't count as discriminatory in and of themselves. And indeed, this is how most employers find out about their employees' drug use. One of the interesting questions of, I think, concerns the one strike rule, which is basically a policy, employer's policy that says that if an employee or a job applicant fails a drug test even once, then they are disqualified from applying or from continuing their work. And one of the cases in which this kind of policy was discussed was where a guy called Lopez, he applied for a job as a longshoreman in '97, okay? And he failed the drug and alcohol test. And this particular employer even notified job applicants 7 days in advance that they will have an alcohol and drug test, okay? 5 years passed by. 2002, he realizes that he has a drug problem and he seeks treatment. He remains clean, and in 2004, he reapplies for a similar job with the same employer. But the employer has a one-strike rule. So for them, it's he missed out on his opportunity to be hired, and that's it for him. He goes to court and he wants to challenge this decision, but the court and he argues that the one-strike rule discriminates against drug addicts. But the court dismisses this claim. He said that the one-strike rule is not discriminatory because it equally affects people who have an addiction and people who just happen to use drugs or alcohol for recreation. And also, the employer did not intend to discriminate. It just intended to minimize the risk of accidents due to using drugs and alcohol on the job. And there's another option that was discussed in the case where the one-strike rule, even though it's neutral with respect to drug addicts, maybe it has a more significant adverse impact on drug addicts, but the court said that there weren't enough evidence to support this claim. It's called the disparate impact in the law. Okay. Okay, because I don't have much time and I want to leave time for questions. I just want to say that one of the interesting things that are happening right now has to do with treating addictions with drugs, with opioid drugs. And this really raises the question of how do you treat the drug testings at work? And the Department of Justice has recently issued guidelines regarding this and also acted on several fronts to make it very, very clear that discriminating against people because they failed drug tests and because they're using medicine that come up as drugs, opioids, in drug testing is discriminatory in the same way that you discriminate against drug addicts. But then, just to put it out there as a question, I don't know what this means for employers' discretion to apply drug tests and to decide who worked for them or not. One of the things that come up is that when you use a drug test and the person is exempted from, the employer uses a drug test, the employee fails the drug test, but it's because of the treatment and not because of an illegal use, then what also needs to happen is that the treatment occurs under the supervision of a healthcare professional. So that's another thing. Okay. Now I move on to number 2. Okay, so I think that generally, when I think about disability, about the category of disability, there is a move from what is called the medical model of disability to social model of disability. The medical model of disability views disability as a limitation or a disadvantage that results from an impairment. And the social model of disability views disability as a social disadvantage, oppression, exclusion that is imposed on people with impairments because of by the societies in which they live. The social model is considered to give rise, it's like the organizing concept of the disability rights movement, and it's clear that the Americans with Disabilities Act was premised on the idea of combating social exclusion and disadvantage to people with impairments. And we can see it here in the findings of the Act. So people with disabilities have a right to fully participate in all aspects of society. Society has tended to isolate and segregate individuals in the past. Discrimination against individuals with disabilities persist, and so on and so forth. So that's the goal of the ADA. But if you think back about the definition of disability that I discussed in the first slide, a physical or mental impairment that substantially limits one or more major life activities sounds very much like the medical model, right? Now, the problem with the medical model in the IDA is that it puts people in plaintiffs in what Bradley Arhart called the Goldilocks Dilemma. They need to be, they should avoid being, okay, so courts find them as either too disabled or not disabled enough, because they are either not disabled enough, so they don't have an impairment that substantially limits one or more major life activities. And if we think about the school bus driver that I talked about earlier, one of the things that the court said is, even if I assume that she wasn't addicted, it didn't affect her work. She worked perfectly well for over 20 years, so it's not a disability. Okay, so that's one. But the other problem is that even after they qualify as disabled, they also have to show that they are qualified to do the job. And if they can't qualify to do the job, if they have behavioral problems, absence problems, and so on and so forth, they lose on both ends. Addiction and the social medical models. I think that addiction fits both models. I think that the ADA manifests a tension between the social model that underlies its goal and the medical model that informs the definition of disability, at least the first prong of the definition. But I think that, okay, addictions can, in specific cases, meet those criteria. Yes, we have the problem of being too addicted or not addicted enough, but addiction in itself is often a cause of significant limitation in major life activities. And one of the cases where the plaintiffs actually spelled out what is limiting about their addiction, and these were two prisoners who were serving terms of 15 years to life for second-degree murders. They said, and they had a history of drug abuse and drug addiction, and they said that their addiction substantially limits their judgment, ability to learn, ability to comprehend the long-range effects of their acts, and ability to maintain stable social relationship and stable employment. So I think that depending on the circumstances, people can make this claim. On the other hand, I also think that addiction is a disability under the social model of disability, because people with addictions are typically subject to social exclusion and the stigma, due to stigma and fears. So the question is really, to me, why is addiction and drug abuse and addiction to drugs excluded from the ADA. And I think it has to do with a different model of disability called the tragedy model of disability. Generally, this model views disability, maybe I should just say that I present the models as I understand them, and people don't agree necessarily on exactly what each model says, but the way that I talk about the tragedy model is the views that are associated with this kind of view of disability. So generally, views that are associated with the tragedy model of disability view disability as an impairment that reduces people's well-being and quality of life, and therefore it calls for people's pity and help. And if treatment is available, so also treatment to ameliorate the symptoms and the suffering. And one of the things that I think are implied or implicit in this view of disability is that people do not choose to be disabled, and being disabled is not your fault. So these kind of assumptions. Now, if we think about the tragedy model and we think about addiction, this can explain what's happening here. It's unlike other disabled persons who invoke desire to help, people with addictions invoke fear. And we can think about the court's reasoning about that the employer will have should have a reasonable amount of confidence that the problem will not occur with the drug abuse, and the fear that the person will who is using drugs and alcohol will engage in accidents and stuff like that. Secondly, unlike other disabled persons who invoke pity, people with addictions invoke moral judgments. And in the case of Lopez that I mentioned before, the court reasoned about the one-strike rule that applicants who could not, that the employer did not intend to discriminate against addicts because it merely thought that applicants who could not abstain from using illegal drugs, if after receiving advance notice of upcoming drug tests, showed less responsibility and less interest in the job. So we see a moral judgment. How come you're not able to stop yourself? And third, unlike disability, which is not chosen, acting on addiction is chosen. And that's a very interesting case that I want to highlight. So this was an employer of the city in the Department of Aviation, and he was arrested for possession of cocaine, even though it was not during work hours. He immediately went to rehab, but still he was dismissed 2 months later, I think, because of his possession of drugs. Now, what the court says in this case is that that his behavior is not like a driver who without warning experiences an epileptic seizure which caused him to veer onto the sidewalk and strike a pedestrian. Whether or not his alleged disability of drug addiction created a wholly involuntary need to possess drugs, Furness, is the plaintiff, made a conscious choice to actually possess drugs. Whether or not his alleged disability of drug addiction created a wholly involuntary need, his acting on it is what counts. So it was a choice. Okay. Okay, and I will conclude with 2 more slides, so I'm good with time. Okay. My starting point is that the category of disability is socially constructed. What do I mean when I say it's socially constructed? Not that there are no such thing as disabled people, not that disability doesn't exist, but rather that the limits of the category may change regardless of the changes in the properties of the people who are part of the group. So what are the implications of the social construction thesis in the context of discrimination law? Does it mean that we cannot criticize the addiction outlier? Does it mean that every definition is fine, all the same? No. And here I want to draw on a recent work by Elizabeth Barnes, who used the idea of ameliorative project for defining social categories that Sally Haslinger developed. And she said that when we think about what social categories are, social kinds, we need to think about what the definition of the social kind is for. We need to think about it as something that serves a certain goal of social progress. And for Elizabeth Barnes, in the context of disability, this means what disability is. Disability is a category that that people found useful to explain shared experiences of oppression and to organize themselves in a civil rights struggle. So for Elizabeth Barnes, the ameliorative project of the category of disability is a universal project of the disability rights movement. What I want to use Haslinger's idea for is not universally but locally, to define disability in the context of anti-discrimination law. It's a local application of the ameliorative project. And to ask ourselves, when we define disability in the context of the law, what should it mean? It should mean what the law is for, what the anti-discrimination law as a civil rights law, which promotes on different view, but let's say generally equal opportunities, anti-subordination, diversity and exclusion. The definition of disability needs to somehow correspond to this, to these goals. And I think that the definition of disability in this context applies to addictions. I don't find a reason to accept the tragic model of disability into disability anti-discrimination law, because I don't see how it promotes the goals that civil rights try to promote. So my conclusion is, even though it's stated very strongly, but maybe it's not as strong, but my intuition is, for the time being, is that the addiction outlier and disability discrimination law lacks justification. And this is because it rests on a conception of disability that has no place in disability anti-discrimination law. That's it. Thank you very much.
Okay, we'll just take a quick 1 or 2 minute break. Grab a drink if you need to, gather your thoughts, and then we'll have a Q&A. Sure. Yeah.
I think not really
No? Yeah. Okay, so on to Q&A. As before, raise our hand if you have a substantive question, and finger if you have a very specific follow-up, and keep your hand up until I can give you the nod, and then I'll add you to the list. So it's fine.
Thank you very much, Adi. That was really interesting. I learned a lot. I just have a very simple question. I agree with you about it was very helpful at the end about the tragic model. It does apply to addictions. I think you're right. There's fear of addicted people, some of it legitimate, possibly. There's moral judgment, some of it legitimate, possibly. And there's some truth, of course, in the idea that addiction is a choice, and that it is the addict's fault. But we'll talk about that other times. Hannah will talk a lot about it, probably. But so one question I just had is, isn't there a simpler explanation, though, for the sort of drug laws that doesn't get into this sort of whole disability model, which would just be public safety? So when the case that you brought up was fascinating because it involves Rhodes versus Board of Education, 2004, you said, school bus driver. I mean, one would think that it's sensible to have some rules that school bus drivers, airplane pilots, there's like a good movie about that called Flight, I think, with Denzel Washington. Did you ever hear that?
Yes.
He has a little cocaine and alcohol problem, and he drives planes. I mean, so why couldn't we just go that route and say, so we're not going to get into the business about whether people, choose an addictive lifestyle or not, but for reasons of public safety, we're just going to, as it were, err on the side of prudence.
Right. So great. Actually, that's an excellent question, and I really thank you for being the first one, because I was considering maybe I should start with saying this before the question. Basically, the law doesn't say she has to remain a school bus driver. It says that she has a disability, and then there are different options for her. One of them is to transfer her to a different position where she's not driving a bus. Another option is to give her time to recover and maybe administer additional tests. So there are different mechanisms, but what happens here is that they just exclude them altogether. And my critique is not that I want to have I don't want to be in an airplane where the pilot is drunk, but I do want to push a little bit more on this categorical exclusion and say, let's look at people individually and assess their abilities. By the way, the movie is a great example, because there he was drunk and made the best landing that saved the plane. And then they discovered that he was drunk and addicted because of that landing. But so things can, and when I think about the notion of functioning alcoholics, functioning addicts, this is exactly what I'm thinking about. So, okay, there is one thing if we want a moralistic workplace that doesn't involve anything, but if what we really care about is the functioning employee. So, okay, so let's see, where do we go from there?
That's good.
I actually just had one quick thought on the I think this can also get this question of like choice and not your fault can also get interesting for some mental disorders, because for example, with something like an eating disorder, one could also say there's an element of choice there. So I think this distinction is also interesting, but it's not really my question. It's my question around the maybe particularly the legal stuff was also just what are your thoughts, or whether you've looked also on questions of race and ethnicity to do with this, because I think in the US, the political and legal history is also quite steeped in considerations that have to do with race, and kind of related to that, but possibly its own independent thing, how the framing might change with kind of the more recent opioid epidemic that sort of brought addiction to the spotlight of society, I think, but also I think in some sense softened the discourse around, or made the discourse around it in some cases more compassionate, which I also have a then race question about. But I was just wondering if you had any thoughts or had looked at this from this perspective too.
Yeah, a very interesting question. I don't know about maybe the discourse has become more compassionate. I don't know. And if it did, it's interesting. I do think that the Department of Justice becoming more involved in this and trying to utilize the ADA to fight the opioid pandemic is definitely shows that there is something there. I think that the problem, the social disadvantage facing people with addictions is definitely intersectional. It intersects with poverty, with race, with different issues. One of the cases, one of the interesting cases that I found also about that I read about drug testings had to do with the drug testing that use people's hair. And the hair, you know this case? Okay, so this kind of test really found significantly more people of color to be using drugs, but that's a different question. I think that also the intersectionality is interesting. In one of the cases that I mentioned, that she was arrested and she didn't have money to post bail, because if she had money to post bail, all of this would have been avoided. So it's intersect the problem of addiction and the law's protection intersects with poverty, with race, with all these things.
Thank you.
There's a follow-up question from you.
I would just like to underline the fact that you said that you show something very interesting, that on the one hand, the law gives some very specific and formal, we could say, definitions of disability. But on the other hand, there is a moral paradigm that is underlying all this situation that makes court, in a certain form, try to condemn in spite of the formalities of the law. It means we see addict people as being blameful for their acts, and this is a base that is present there underlying all judgments. And I think it's very interesting that you identify that, and at such a point that it takes court to find a way not to categorize those people as being addict. My question is, do you think this underlying background, this underlying moral background, which takes us to consider these people as being blameful for their acts, is something that can so easily change, as, for example, with your proposal that addict people will be considered as being disabled? Do you think it can easily change?
I don't know. No, I don't know. Sometimes I think that this kind of work that we do, maybe just putting it out there, maybe it can make people think differently about things, but I don't know.
Sorry, just one of the things that struck me related to this is, the disease model of addiction that various people don't agree with, but the disease model would, of course, undermine that it's somebody's choice and that it's their fault. And it's in some ways, my impression in the US that the disease model is the most accepted model of addiction. And so in some ways, it's very strange that the courts aren't taking on that kind of medicalized notion of addiction and sort of attributing both, and the question of whether they should, the background questions about what the nature of addiction is a different one. But it is my impression, I don't know if it's others as well, that in the US, that is kind of how people have been in exactly to destigmatize, right?
Right.
And exactly to undo
Right.
sort of the blameworthiness and
So I
the
agree.
stigma.
So one of the things that I found interesting is that I don't think that they doubt that it's a disease. I think that they distinguish between a person doesn't choose to become an addict, it's just a disease, but whether one chooses to act on the addiction is the choice that the court is trying to, I mean, I'm not defending, I'm just saying this is the kind of rhetoric that is being applied to try to distinguish between a person who has a seizure and a person who acts on their addiction. And another thing I wanted to say is that I think that so the disease model of addiction is one way of looking at it, but also if we think about disability more broadly, we don't normally, courts do not normally question how did a person become disabled and whether they had a choice or moral blameworthiness with regards to the process leading to most of the people with disabilities, I don't know if most, but a lot of the people with disabilities became disabled during their lifetime, were not born disabled. The question, how did it came about? Whose fault was it? Maybe a person was reckless driving, maybe no one's questioning that. Once a person is, to take the paradigmatic example, in a wheelchair, no one questions whether they had anything to do with the car accidents in which they became involved. And so, yeah. So it's a different, so I'm taking it from a different angle to compare it to other disabilities that are protected.
There's a substantive new question or follow-up, because there are two substantive questions left from Hannah and then you. So we just, another question, cool. Okay, so we'll go to Hannah and then to you for substantive new points.
I will do a quick follow-up and then a question as well. So the quick follow-up is just that in the US, I totally agree with Ellen. It's very, very disease focused. But the criminal law also, despite it being disease focused, doesn't make allowances for addiction in a similar way. So the law seems very obtuse, right, to whatever you might think might follow from the fact that the cultural conception of addiction is a disease, but in different dimensions of law. So I love this talk. It was so interesting. And I love the pragmatic use of law. So you brought out so nicely how disability has multiple meanings. It's sort of silly to pretend there's one thing it is that we could define. And so then the question is, you know, what kind of definition is used in a context such that it might have pragmatic ends that we want to endorse. And I guess I was thinking about the use of disability in law as a way to destigmatize, protect, and help people with addiction. And I just wanted to ask how far you thought that could go. So the cases you brought are all cases where it looks like there may be clear discrimination and it's a civil suit, right? So somebody is suing someone else. But as I understand it, in many jurisdictions, disability law requires employers to make reasonable adjustments. Yeah. And, you know, that's a very different kind of scope. And you could see, I was sort of thinking like, well, there are some ways this could be great. I mean, maybe it could help with like harm reduction projects, right. But then other ways in which actually I felt anxious about the idea of reasonable adjustments when you think about what some of those details might be, right? It feels different. So I guess, you know, in a safe space, I just wanted you to comment on that. Like, are you happy with all those implications? How far would you go? Because if not, then maybe disability isn't the right place to try to affect these social changes through law. Because I think it will push in that direction.
Yeah, thank you very much. Whether I am happy with all the implications, I think I'm not happy with some of with the trend of narrowing down the protection to the extent that a person signs into rehab, spends 2 months in rehab, goes back to work, and then being dismissed. And I think that this is because I put a lot of emphasis or value, or maybe just a false hope on employment. I think that people cling to their employment. And I think that knowing that your work is still waiting for you, because some of these cases, they really show how people call their boss from rehab to, call their sister, tell him that I will be there in a week. And then the rehab center says, well, he will be with us until further notice. And then the employer says, what is further notice? It means forever, So these things, I think really, I don't know, because I'm not a therapist, but it's my intuition that they affect people in a bad way, that they undermine their chances of recovering. So it's not that I don't endorse the flight movie scenario, but I think that employers should be more accommodating to this problem that people face. And it needs to happen in a way that they can, of course, accommodate. That they can provide. The law also provides limits to the duty to provide reasonable accommodations, such as undue hardship. So if the employer shows that providing the accommodation, let's say, keeping the job open for the person to recover for 6 months, let's say, is undue hardship, then they're not legally obligated to do that. But there are things in between, and that's what I'm trying to push for.
Okay, thanks for that.
Hello. Hi. First of all, thank you so much. I thought the presentation was really straight to the point. So everyone, whether they knew or nothing about law or employment, I feel like the presentation was straight to the point, like how I like it. And I hope my opinion / question is not too controversial, but basically, I come from a mental health perspective, mental health industry. So to me, I find it really, really hard to think as addiction as a disability. And also, when you said we look at people with addiction as in society, you look at them with fear. I feel like that's understandable, because when we listen to the word addiction, the first thing that comes to mind is aggression, lack of control. But for example, if you say someone has anxiety, you don't associate those words with that person with anxiety. So I feel like it's normal that society kind of fears people with addiction. I feel like that's normal. And also, I feel like in your presentation, you didn't connect mental health disability with addiction disability. And I feel like in my perspective, addiction is a symptom of disability. So I'd like to know your questions surrounding that.
Addiction is a symptom of disability. Okay, I think that for some, if we go now to the medical discourse, I think that addiction is considered a medical condition in and of itself in some cases. And I think that it can sometimes be related to some other medical conditions. Is that right? Okay. And now with regards to the fear and stigma. Now, if we would have talked about people who are depressed or have personality disorders or other kinds of mental health issues 20 years ago, the fear and stigma would have been as strong as it is today about addiction. So one of the goals of anti-discrimination law is to fight fear and stigma and unsubstantiated fears. Now, obviously, these are all things that we need to figure out with regards to the specifics of each case. There are many different protections in the law, like the undue hardship that I mentioned, like the direct threat defense, that if a person poses a direct threat to employers, to the employer or to colleagues, then they are not protected under the Act. The claim here is more modest in a way that I'm trying to criticize the categorical exclusion. I don't think that finding that a person is violent due to addiction, related to an addiction, linked to an addiction, or whatever is something that society needs to embrace. But I don't think it's the case in all cases. I think that sometimes it's not the case. And we should be more open to accepting that.
See other hands going up, but we are pretty much out of time, so we might have to wait for a short break and then. So, thank you very much, Alice.